Welcome to K&L Gates Working Wise podcast series. My name is Jimmy Ma, and I am an associate in the firm's Los Angeles office. And I am a member of the firm's Labor, Employment, and Workplace Safety Practice Group. In this podcast, I will discuss recent developments in the EEOC's reporting requirements for employee pay data. Let's begin with some background on reporting requirements for equal opportunity-related data. Since 1966, federal statutes and regulations have required employers to file annual EEO1 reports that disclose data regarding protected characteristics such as race, gender, and national origin. The EEOC and the Office of Federal Contract Compliance Programs use the data to support civil rights enforcement and to analyze employment patterns, such as the representation of women and minorities within companies, industries, or regions. In an effort to identify and combat pay discrimination, in 2016, the EEOC announced that it intended to expand the EEO1 forms to include pay data information. This data collection was subject to the approval by the White House's Office of Management and Budget, or OMB. During the final months of the Obama administration, the OMB granted approval of the EEOC pay data requirement. The Trump administration, however, revisited the issue and eventually halted the pay data requirement after concluding that it lacked practical utility, was unnecessarily burdensome, and did not adequately address privacy and confidentiality issues. This decision led to litigation, which culminated in the case of National Women's Law Center v. Office of Management and Budget, recently decided on March 4, 2019. In the decision, a federal district court in the District of Columbia ruled that the EEOC must proceed with pay data collection, because the OMB's decision to revoke the pay data requirement was arbitrary and capricious. The court reasoned that the OMB violated administrative law by failing to point to a change in circumstances or to provide a reasoned explanation for reversing its 2016 approval. Therefore, as the law currently stands, employers with 100 or more employees, as well as federal contractors with 50 or more employees, must now file an annual EEO1 report with two components, each with its own deadline. Under the EEO1's traditional data collection, Component 1 collects gender, ethnicity, and race demographics for 10 specified job categories. Component 2 is the new reporting requirement, the subject of the ruling in National Women's Law Center. Component 2 collects an aggregation of pay data and hours worked by all full and part-time employees in 12 predefined pay bands, broken down by gender, ethnicity, and race, in the same 10 specified job categories as Component 1. These pay bands are based on calendar year W-2 income. Because Component 2 seeks aggregated data, employers are not required to submit individual pay or salary data. Of course, these requirements may be put on hold, as litigation over Component 2 is still ongoing. The Department of Justice filed a notice on May 3, 2019, appealing the district court's order in the National Women's Law Center case. But absent a stay on the district court order by the D.C. Circuit Court of Appeals, employers will have to submit data for Component 2 by the designated deadline of September 30th. As such, employers should be making preparations now. Regardless of what happens with the National Women's Law Center case, employers should be taking proactive steps to evaluate their pay policies, given the recent rise in pay equity lawsuits. With the guidance of legal counsel, a pay equity audit can help employers identify pay disparities, determine whether they are caused by discriminatory or non-discriminatory factors, and remedy any unjustified disparities. And if an employer happens to receive a pay equity claim after they have conducted an audit, they will be in a better position to explain any pay disparities in their workplace. In our previous podcast episode, titled Proactive Strategies for Pay Equity Issues, we elaborated on the benefits of conducting pay equity audits and discussed recent trends in pay equity lawsuits. You can find a link to that episode at klgateshub.com. We hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.